Constitution, week 5. So, we're going to talk today about the transfer of power from Section 96 courts to provincially created tribunals. Cases we're going to look at are Tomco 1975, a reference regarding adoption in 1938, John East case in 1948, Toronto versus York, 1938. We're going to look at the three-step process for determining if the power is transferable according to or created in the Residential Tenancies Act reference to the Supreme Court. And there's also a couple cases that followed that used that process. So the big picture is that Section 96 courts are described in the Constitution, and they are superior district and county courts. The feds have the power to create these courts and appoint the judges, and their power is protected by the Constitution. So how can the provinces create judicial bodies that serve the same function? Or more importantly, why do they want to? Well, the provinces do have power over the civil and property laws of the province, and in order to administer those laws, sometimes it's helpful to administer them in a tribunal setting, a specialized tribunal setting, as opposed to a general court setting. Now, the argument, though, however, is that some of these specialized tribunals, jurisdictions or powers, infringe on the powers of the superior courts, and thus the province can't appoint judges to them. I'm not sure if they could create them or not, but anyway. So if we look at Section 96 strictly, then that would restrict Section 92, the power of the provinces to administer their power over civil and property legal matters. I think they have they've been given the power to administer. Anyway, I'm a little hazy on that, but this is the big picture of transferring power from Section 96 to provincial specialized tribunals. And the alternative is, of course, that the Section 96 courts are protected so that uniformity can be maintained in the Canadian judicial system. So we'll start off by looking at Tomco versus the Nova Scotia Labour Relations Board in 1975. This was precursor to the Residential Tenancies Act, and the result was to focus on the administrative structure of the body rather than the remedy. So this is a pretty specific point. We'll get to some broader points when we look at the cases cited in the Residential Tenancies Act, but this is quite specific. So when determining whether the specialized tribunal is infringing on the power of the Section 96 courts, we need to look at the administrative structure rather than just the remedy. So if the remedy is pecuniary, well, that's an issue, but we need to focus on the administrative structure. So who's collecting evidence, who are the parties involved, who's making the decisions, those kind of issues. So the issue here was the validity of Nova Scotia Labour Relations Board authority to issue a cease and desist order. And it was argued that this jurisdiction is analogous to a Section 96 court, and their ability to issue mandatory injunctions to halt illegal activity. So the Provincial Labour Relations Board's cease and desist power versus the historic Section 96 court's mandatory injunction to halt illegal activity power. And this case kind of confirmed the power of a specialized agency to issue a cease and desist order in the context of a labor dispute. So it was limited to the specialized context of the tribunal. Here, 96 courts could issue mandatory injunctions to halt illegal activity, which is quite broad, and as opposed to the Nova Scotia Labour Relations Board, which has the power to issue cease and desist orders in the context of labour disputes, which is quite narrow. And in the decision they said it is not the detached jurisdiction or power alone that is to be considered, but rather its setting in the institutional arrangement in which it appears as in exercise and is exercisable. So they're also looking at, it's not just the power, but they do need to consider the institutional arrangement. So what is the role of the Nova Scotia Labour Relations Board, and what are they trying to do, and how are they trying to do it? Is an important consideration, and this will lead us to policy justifications later on. So this was not a strict interpretation of Section 96, and it supports the expansion of powers leading to the Residential Tenancies Act test. So in that case, in the Residential Tenancies Act, I think I'm just going to refer to that to the RTA now. So the big picture is the decisions, two decisions in 1938 and 1948, which sort of set the scene for this controversy between giving the provinces autonomy to create a more efficient judicial system and balancing that with the need to protect the uniformity desired by protecting Section 96 courts. So we're going to start with the reference on adoption. So in common law in 1938, there was no adoption, and the question was whether an adoption decision could be, or that power could be conferred on an inferior court. In this case, it was important to note that Justice Duff said that inferior courts are not fixed forever. So they can change, they don't have to be exactly as they were at Confederation. And he says the question which must be asked was whether the jurisdiction conferred upon magistrates under these statutes broadly conforms to the type of jurisdiction generally exercisable by courts of summary jurisdiction, rather than the jurisdiction exercised by courts within the purview of Section 96. So this is an early test to see if it's intruding, if the powers are intruding, and what he's saying is that we need to see if the power that the province is asking for broadly conforms to the power an inferior court had at the time of Confederation. And he looked at the historical practice in England and concluded that the jurisdiction conferred on the magistrates under the legislation before the court was analogous to English poor laws and courts of summary nature rather than superior courts. So courts of summary nature here are analogous to inferior courts, and thus the provinces were given the power over adoption. And that was a bit of a liberalization, I suppose. Some might say it was just the right decision. But in the exact same year, a court came up with quite a very different test, I believe. So in Toronto, York, Ontario Municipal Board was not qualified to interpret contracts. This was their decision. And according to our teacher, that was an interesting thing because that's all they do. And they already decided that small claims court, an inferior court, can interpret contracts. So the fact that the Ontario Municipal Board was interpreting contracts meant they had a judicial function, meant that they were infringing on the Section 96 courts, which is a rather strict interpretation. So here they looked at what the court was, what the tribunal was doing in a very broad sense, interpreting contracts. They didn't narrow it down as was done in the previous case where it was cease and desist orders only in labor relation cases. Here they look at it as interpreting contracts, which if you look at it that broadly, then it's going to easily intrude. So this decision was the apogee of any function which in 1867 had been vested in Section 96 court must forever remain in this court. This is sort of the peak of a strict interpretation of 96, or a strict application of Section 96 of the Constitution. Dixon in the Residential Tenancies Act says that he held that the municipal board was in pith and substance an administrative body, and the impugned judicial functions were severable from the administrative powers given to the board under its enabling legislation. There was no analysis of the interrelationship between the judicial and administrative features of the legislative scheme. The assumption was that any attempt to confer a Section 96 function on a provincially appointed tribunal was ultra vires the legislation. And what he's getting at here is criticizing the decision in Toronto and York for the fact that they didn't analyze the interrelationship between the judicial and the administrative features. And if that's done, sometimes the judicial features of the legislative scheme are an important and perhaps necessarily incidental aspect of the tribunal. But it's important to at least analyze it, as opposed to just strictly saying a broad interpretation of this tribunal's powers intrudes on Section 96 court, and thus it's ultra vires. So moving on to 1948 in the John East case, this time in the context of a transfer of jurisdiction from a superior court to administrative tribunal. It was initiated in the Privy Council, and the style of cause is Labour Relations Board of Saskatchewan versus John East Ironworks Limited. In this case, we see further development of the test to see whether or not these powers can be transferred or conferred on a provincial court. So Lord Simmons proposed a twofold test. The first limit of the test is to ask whether the board or tribunal exercises judicial powers. If the answer to the initial question is negative, then that concludes the matter in the favor of the provincial board. So if the provincial board isn't doing anything judicial, then there's no reason to stop it. If, however, the power is in fact judicial, then it becomes necessary to see if that power is analogous to the superior district or county court. And this is a subtle reformulation of Chief Justice Duff test from the adoption reference, where he just wanted to know if historically the powers were within the inferior court. So here we're shifting our perspective a little and looking at whether it doesn't actually need to be part of an inferior court historically, it just needs to not be part of a superior court historically. And this makes a lot of sense if the policy behind Section 96 is to protect the superior courts. Though it does create the issue of unique jurisdiction isn't automatically within the power of Section 96 courts. So additional liberalizing comments by Lord Simmons. He suggested that it was not absolutely necessary to consider whether there was a true analogy between the impugned jurisdiction and the jurisdiction of the summary courts. It would be sufficient for a constitutional process to establish that the power of jurisdiction was not one traditionally following in Section 96. And that's just what I described, of comparing it to the inferior courts historically, or comparing the impugned legislation to Section 96 courts. So in this case, the Privy Council did not find it necessary to give any final answer to the initial question, whether the power in issue was judicial. The case was resolved on the ground that in exercising the tribunal, the power of the tribunal was not analogous to a superior county or district court. which appears they might have jumped to question 2 in Lord Simmons' test, and just determined it wasn't analogous to superior court power, and thus it's all good. And this is very analogous to the test that's defined in the Residential Tenancies Act. Additional notes in this case, though they didn't look at whether it was judicial or not, the decisions they made related more to social policy because they were hearing disputes between employers and unions rather than to individual parties. The board was neutral with a legally trained chair, and the advocates were not lawyers. And the underlying purpose was to promote the economy by facilitating industrial peace. So it wasn't infringing on Section 96 court's power because it wasn't judicial, I suppose, is a good way of looking at that. And it wasn't judicial because they weren't dealing with disputes between 2 individual parties. They were more arbitrating, I suppose, between 2 collectives in order to determine a social policy which would hopefully lead to the facilitation of industrial peace. So this is a much more broader social purpose than reconciling disputes between 2 individual parties. So we get to the reference regarding the Residential Tenancies Act of 1979. And here, this act is a reference to the Supreme Court to see if the province of Ontario has the power to, it's all written down here. Anyway, has the power to enforce, has the power to force tenants to comply with their orders or force landlords to comply with their orders, basically. So the Attorney General advances 2 submissions to refuting the Court of Appeals decision. So the Attorney General is of Ontario okay, let's just read it. So prior to 1867 in Upper Canada, the only tribunals which could make ejectment orders were the Court of Queen's Bench, the Court of Common Pleas, the County Court in limited situations, and that only the Court of Chancery could make orders of specific performance. In this case, they're referring to, I suppose, staying in a lease that you've left, or perhaps vacating the apartment might be an example of a specific performance. Or issue mandatory prohibitory injunction orders. The settlement of disputes between landlords and tenants, including the termination of tenancies and eviction of tenants, has thus always been within the exclusive jurisdiction of the Superior District and County Court of Judges, both before and after Confederation. So, the Attorney General advances 2 submissions refuting that the powers are, so that the power to order eviction of overholding tenants was conferred on county court judges as persona designata outside the structure of the superior and county courts. Thus, this power is recognized as not exclusively a power of the Superior District or County Court within the intent of Section 96. By analogy, the power to make orders of compliance is not a power exclusively within the jurisdiction of the Superior Court. So what they're saying here is that the Court of Appeal said that the powers of settlement for disputes between landlords and tenants has always been in the jurisdiction of Section 96 courts. And what the Attorney General is saying, the Attorney General for Ontario is saying, is that it wasn't exclusively within their power. And they issue this second submission. even if jurisdiction over landlord and tenant matters was exercised